Hello everyone, my name is Eric Hall, and today I'll be discussing why Belizeans must vote no to the ICJ by Mr. Hubert Enriquez. Unfortunately, we were unable to find any information regarding Mr. Hubert, and as such a bibliography will not be provided along with this presentation. When faced with a territorial dispute between Belize and Guatemala, we can get positive results through the means of two options: the political route or the legal route. There is a third proposal that combines both of these methods. However, it only serves to highlight the ineffective approach adopted by Belize so far. The political route refers to the actions of stakeholders, which are the citizens at home or abroad, politicians, civil society, international friendly governments and supporters, regional and interregional bodies, and internationally the United Nations General Assembly. The legal route refers to the determination based on legal international principles enunciated by a panel of judges after a process of evidence gathering, deliberation, and the delivery of a binding judgment. The political route. Ever since our independence in 1981, Belize and Guatemala have engaged in a number of negotiations to try and settle the dispute. These are namely the 1992 Maritime Areas Delimitation Act, the Facilitation Exercise of 2000, the Conference Building Measures in 2003, the Agreement on Framework for Negotiations in 2005, and the Placentia 13-Point Accord in 2014. However, very little progress has been made to settle the dispute, as these initiatives only serve to show that Belize has done its part in trying to resolve it. Internalization. As of recently, Guatemala has taken claim of the entire Sarstone River and has refused to allow the Belize Defense Force soldiers to visit the area even though the river forms a part of our southern border. As of right now, Belize can take the dispute to the world stage. According to Dr. Showman, the Guatemalans have driven the agenda. Now it behoves us to take back the agenda, set our goals, and pursue them. On the 11th of November 1980, the UNGA passed on Resolution 35/20, which facilitates the process of setting Belize free from colonialism. In anticipation of future Guatemalan recalcitrants, the resolution also mandated the relevant organs of the United Nations to take such actions as may be requested by the administering power and the government of Belize in order to facilitate the attainment of independence by Belize and to guarantee its security and territorial integrity thereafter. When the UNGA wanted Belize to gain independence back in 1975, they had a vote in which 145 countries participated. Out of the 145 countries, 144 voted for Belize, with Guatemala voting against it. When faced with Guatemala's transgression, the resolution went further. The threat or use of force should not be applied to prevent the people of Belize from exercising their inalienable right to self-determination, independence, and territorial integrity. The Resolution 1514 from back in December 14, 1960 helped to strengthen the UNGA's position of granting independence to Belize. When the US takes action to secure the integrity of Belize, they deploy the Security Council, which is responsible for maintaining their national peace and security. The Council may opt for enforcement measures including economical sanctions, arms embargoes, financial penalties and restrictions, and travel bans. The legal route. Special agreement. On December of 2008, the governments of Belize and Guatemala agreed that they would go to the International Court of Justice. The court will determine any and all legal claims that Guatemala has against Belize. However, according to Dr. Showman, in reality, nothing is realistically applicable right now, neither the special agreement nor the protocol amending it. The ICJ. There are currently 15 judges within the ICJ, each of which are elected by the United Nations General Assembly and served for a period of 9 years. According to Belizean historian Dr. Herman Bayard, the ICJ has dealt with over 127 cases ever since it was founded in 1946. However, only 27 of these cases have dealt with territorial disputes. According to Article 59, the decision of the court has no binding force except between the parties and in respect of that particular case. What does this mean? This means that the ICJ's judgments are not necessarily precedent. This means that the ICJ's judgments are not a warning or an example, but the real deal. If the ICJ was to say that half of Belize now belongs to Guatemala, then that means that half of Belize now belongs to Guatemala. There is nothing we can do about it. It also has to be noted that the ICJ has no parliament to make laws. Not even the UN General Embassy makes laws for the ICJ. The Belize legal position. From what we know, Guatemala states that it inherited Belize from Spain based on the doctrine of Iuti Possidetis. However, Belize doesn't recognize this claim since Great Britain acquired good title over Belize via the acquisitive prescription and historical consolidation before 1821, which is the date of Guatemala's independence. So it has the right to defend itself as an independent nation. Belize also relies on the 1859 Boundary Treaty and the 1931 Exchange of Notes Treaty. However, Guatemala contends that it does not recognize the 1859 Boundary Treaty because Britain failed to fulfill one of the terms. The conclusion and way forward. Belize has a compelling legal case against Guatemala on the basis of the internationally recognized principle of self-defense. However, most court cases are not won based on merits, but on the skill and dexterity of the legal team. As I've said before, the ICJ's judgments are not necessarily precedents, meaning that they are not warning, but they are the real thing. This is shown in the case of Nigeria versus Cameroon. In 2002, the ICJ ruled that Bakassi Peninsula, with over 300,000 Nigerians, be cut from Nigeria and given to Cameroon, with all of the businesses, homes, farms, graves, everything being given away. If the ICJ were to decide that half of our country would belong to Guatemala, then we must move out and give it to them. There are still many other questions that are not yet answered. One of them is, what about a contingency plan for Belize? We have no contingency plan. In the case that the ruling of the ICJ would result in the displacement of billion lives, what would we do? How would we relocate these people? Where would they stay? We do not have a contingency plan for this kind of thing. Many people want for us to take the dispute to the ICJ. However, they still want our territory intact. This is something that many of them don't understand. By going to the ICJ, we run a great risk of losing a portion of our country. Going to the ICJ is a waste of our resources and puts us at risk not only from Guatemala but also from Mexico and Honduras. Alternative to the ICJ is the pursuit of the political mandate declared by the United Nations General Assembly when it granted our independence with all our territory intact. If we wish to challenge Guatemala, we can only do so with the support of the international community at the UN, which rules in Belize's favor. However, in the past 35 years, it is clear that although Guatemala spoke peace, they are prepared to use force to obtain their objectives. So why has Belize not moved to enlist the participation of the UN Security Council in the dispute? They clearly had a chance to do so, and it would greatly benefit our country. However, we may never know the answer to this question. A document entitled Some Consideration for Redirecting Belize's Diplomatic Approach to the Territorial Dispute with the Republic of Guatemala could be used as an alternative to the ICJ's binding ruling. We reiterate that the most salient principle of this dispute lies in the principle of self-determination. It is when modern international laws do not recognize the survival of a right of sovereignty based solely on historic title. This means that historical claims and feudal pre-colonial titles are merely relics of another international legal era. They do not come into play when we are discussing the rights of a country in our modern world. Suggestions from Belizeans. Many Belizeans are already tired of the dispute that is going on, so they take it in their own hands to try and contribute a little to it, such as leveraging our purchasing power and services against Guatemalan products and consumers, or that the letters be written to the Vatican for the annulment of the 1493 papal bull by Pope Francis, which was the main reason for why Guatemala thought that she owned Belize, or that the reestablishment of the Department of Patriotism, and that schools should place a greater emphasis on our Belizean history and heritage. These days, our current leaders are too preoccupied with petty domestic and party political issues that they do not focus that much on the debate on the dispute that is going on right now. Belize should invest its resources wisely, whilst at the same time empowering its citizens to compete in the domestic and the global economy. We really should not go to the ICJ. It's just too much of a risk. We might end up losing a large portion of our country to Guatemala. There are many other reasonable options out there that we can rely on.